5, Tabani Wiseman Zulu applicant number 6, Sarah Matawan Namlamlili applicant number 7. By agreement, the indication, and it is accepted by the court, that the offences fall under Schedule 5, and the applicants therefore bear the onus of proving on the balance of probabilities that the interest of justice permit their release on bail. And by agreement, the affidavits in support of the bail application by each of the applicants were handed into the chambers of the court for the court to formalize itself therewith, and that resulted in the affidavits not being read into the record to save time as indicated earlier. And each of the applicants indeed submitted their affidavit with their personal circumstances, which the court will not repeat as for the reason that they said were not read into the record. Safe to say that the court has taken consideration of all of these affidavits and the said circumstances of each of the applicants. As I've indicated, the applicants bear the onus of proving before this court on the balance of probabilities that the interest of justice permit their release on bail. The court is called upon to look at the provisions of Section 60, subsection 4, paragraph A to E, and up to subsection 8 in order to determine whether the interest of justice permit the release of the applicant. Should the court find that the interest of justice do not permit the release of the applicant, meaning should there be any of the factors mentioned therein, the court has to lean towards or incline towards the further detention of each of the applicants. However, if the court cannot find any of the factors mentioned in the said subsection, the court has to incline towards the release of the applicants, bearing in mind that further detention might have impact on the rights of the said individuals, and there are various rights that are affected by this. Indeed, the offences with which they are charged are serious, as Advocate Mason has indicated. The court take cognizance thereof. However, at this stage, the court is not called upon to determine the guilt or innocence of either of the applicants. All the court has to determine and find is whether there is a prima facie case against any of the applicants. And having familiarized itself with the contents of the charge sheet and the accompanying, I would say, mini indictment, the court is satisfied that the state has at least a prima facie case against each of the applicants before court. The state does not bear the onus of proving the interest of justice to not permit of any of the applicants. It is thus not surprising that they did not call any witnesses, and also it was indicated already that the state is not opposed to any of the applicants. And the only reason the state would not oppose the release of the applicants is if the state believed that the interest of justice permit their release on bail, and that neither of the factors mentioned in Section 60, subsection 4 exist. And the court has indicated that I won't repeat the contents of the affidavits by any of the applicants for the very reason that it was not read out into the record, safe to confirm that indeed I've taken consideration of every aspect of the said affidavits as well as the address by their respective legal representative. At this stage, having considered the provisions of Section 60, subsection 4, paragraph A to E, subsection 5 to 8 of the Technology Act 51 of 1977, as well as subsection 9 of the Section 60, the court is satisfied that at this stage, all of the applicants have managed to discharge the onus placed on them by legislature, and as such, the interest of justice permit their release on bail. The following is the order is thus made. Choose number 1. Please stand up, sir. Mr. Mukhesi. Mr. Matlagala. Mr. Sodi. All the accused can stand up. Thank you. Choose number 1, number 7, number 11, number 12. That's granted bail in the amount of 1,000 rand each. 100,000 rand, sorry. 100,000 rand each. Choose number 2 and choose number 9, each granted bail in the amount of 50,000 rand. All the accused are ordered to provide the investigator with their passports, those who have not done so, and those who have arranged to stick to the arrangements made. Accused number 3, granted bail in the amount of 500,000 rand. The matter is thus postponed to the 11th of November 2020 in this court for further investigations. You are all in custody. Bail, as indicated, has to be paid. Should you pay bail, you are each warned to appear before this court at 8:30. You remain in attendance until excused by the court. Thank you.
Just before we adjourn, there's another issue that I wish to just place on record. I did discuss with my learned friend for the state this morning, prior to the commencement of proceedings. Certain electronic equipment of the accused, number one, have been seized by the investigating team pursuant to a warrant of arrest.
Can I just interject? The recording can stop now. Thank you.
Pursuant to a warrant of arrest issued by the magistrate Bloemfontein. That equipment includes, inter alia, a laptop, an iPad, and I think an iPhone. I have been instructed that my instructing attorney is contemplating disputing the validity.
So those are proceedings that are on the go in the Magistrates Court in Bloemfontein, where the 7 accused who were arrested in connection with the Free State asbestos project have now been granted bail. They include, of course, Edwin Sodi, that businessman who testified at the State Capture Commission of Inquiry, the one who got whose company in a joint venture got that contract of 255 million rand, but didn't really do the work themselves, but outsourced it to someone else who then outsourced it to the person who eventually did the work for about 20 million rand, if I recall correctly. That businessman, Edwin Sodi, released on 500,000 rand bail by the Magistrates Court there. They also include, of course, the Director General, that's the head of department of the Department of Human Settlements in the Free State, that is in Timothy Mogesi, who is also appeared. Of course, the accused also include a former mayor of the city of Mangaung, that is Saramatawana Mlamleli. Those were the people that have appeared in the Magistrates Court. Look out for more reporting from our team on the ground there, led by ENCA's Aviwe Mtila. We leave that there for now.